Our law firm is involved in all aspects of franchising and franchise relationships. If a prospective franchisee is looking to buy a franchise, it is at that time that they should hire an experienced lawyer who's very familiar with the rules of engagement and the law and franchising. The Federal Trade Commission requires each franchisee to be provided with an FDD, which is a franchise disclosure document, by the franchisor so that the franchisee can be apprised as to the extent and type of relationship that that franchisee is going to be entered into. That franchise disclosure document has about 23 different items of disclosure that are required to inform the franchisee as to the nature of the business, who the leaders are, whether there's a bankruptcy history, how much is the investment going to be that's required, where are they going to get their supplies or the products, or who are the vendors they deal with, what is the amount of the different layers of investments that may need to be made and placed into this business, and all other sorts of requirements that really help a franchisee understand the nature of the business. One of the most important exhibits in the FDD is the franchise agreement. Franchise agreement that is going to be required to be signed by the franchisee is an exhibit to the FDD, which represents what is the document that's going to govern the relationship between the franchisor and the franchisee. And that document is called the franchise agreement. It is very important that every word of that FDD is read by every franchisee that seeks to become a franchisee, or every prospective franchisee's lawyer that would be hired to undertake the review. Signing an FDD without the prospective franchisee reading it and being fully apprised of what the terms and conditions are in the document is reckless, it's irresponsible, and will likely lead the franchisee down a path that later they will regret.